When you bring somebody new into your organization, it can be really exciting, right? You've got a need, maybe you've been looking for the right candidate and you finally found them. That's great. Here's what you need to know when you're bringing on a new employee from a legal perspective. The single most important thing you can do, you need to have a written employment agreement. Most people will have an offer letter or an exchange of emails or a call, something like that. But it's important that you set out the terms of employment at the start of that relationship. You don't want to get caught up in onboarding and forget to have that document signed. Why is that so important? Because that sets out the rules of the relationship between you. What are the obligations that the employee has to do? You might have an understanding, but that written document is going to protect you and is so crucial. What happens on termination of employment? Under the common law, employees may be entitled to as much as 2 years' salary if you terminate them without just cause. That's a huge risk, and there's no reason you should have it. Have a termination clause in your employment contract. Limit your liability. What if you're worried about your confidential information? What if this employee is going to be the face of your sales force? And if they leave, customers or clients may go with them, or they may walk across the street to a competitor. Protecting your intellectual property, confidential information, non-solicitation, non-competition, these are all things that, if they are properly drafted, can be legally enforceable and hugely important for you and your business. But you need to get them right, and they need to be in place when you bring somebody on. So set a level playing field. Make sure both sides understand what they need to do and what they can't do, and what's going to happen when the relationship ends.